Hi, everyone. Welcome to our webinar, our lunch webinar for today. My name is Roosevelt Sanfilippo. I'm a migration lawyer here in Sydney. I'm also the principal solicitor for the Sydney, for our Sydney branch. And today's topic is visa refuse onshore, your rights, options, court appeals, explain. So what you need to do next to decide whether you can stay or leave. Okay. Right. Also, thank you everyone for attending today. So I'll just start explaining a little bit more about ourselves, about No Borders. Yeah. Sorry, just testing a new camera here. So who we are? We are NB Migration Law is your trusted Australian visa experts with over 27 years of experience. We were founded by Agnes Kemenes, who arrived in Australia from Hungary in 1987. We specialize in smooth transitions to Australia, so let you start a new life down under. So we are, what we do, we are a migration law firm, but we are a law firm as well, and we practice in other areas other than migration, as you can see on that chart. So we offer our clients commercial, we assist our clients in commercial matters, also employment matters, as well property. In Sydney in particular, I'm the principal solicitor in Sydney. In Sydney in particular, we assist our clients with migration law only. And we are working towards actually expanding our branch to offer more services. But in our head office in Queensland, we employ commercial lawyers, employment lawyers, and property lawyers. Okay. Right. Okay. So visa refused onshore. So what you do next can decide whether you stay or leave Australia. So the most important thing to understand is this: a visa refusal is a hurdle, not necessarily a dead end. Correct. Clients tend to, understandably, tend to become a bit overwhelmed when receiving refusals. They'll come to office to discuss their options after refusals, and understandably it is it can be overwhelming. However, the Australian migration system is unforgiving of delays. Your options are time sensitive, and a single missed deadline can permanently close your path to residency. So the Australian migration system had advantage that in some countries we don't see that, which is review rights. So here you can review, you can lodge appeals from decisions that are made by the Department of Home Affairs. My understanding is that in some countries like the US, some visas do not carry review rights. So if you have your visa application refused, you do need to leave the country, right? So thankfully in Australia, once you lodge an application onshore, then you do have review rights, right? So what does a visa refusal mean when you are onshore? So if the Department of Home Affairs refuses your application while you are physically in Australia, the consequences are immediate. So beyond the disappointment, two legal mechanisms usually trigger. One, it's the Section 48 bar. Okay. This is a critical restriction. So once a visa is refused onshore, Section 48 of the Migration Act generally prevents you from applying for the most for most other substantive visas while you remain in Australia. Okay, so it's a common term. So, and usually people refer to you're Section 48 barred, so you can apply for a visa in Australia. The Bringy visa countdown. Your current Bringy visa, usually a BVA or a BVC, we now have an expire clock. Usually you have 35 days from the date of the refusal decision before your bridging visa ceases, unless you lodge an appeal, right? So automatically the system calculates that 35 days from the date when the application is refused. Okay. Now that's when it is important to look for expertise advice, because for certain visas, an application may be refused, but this is not necessarily a visa refusal. Okay. Also, you might think that you are Section 48 barred when in fact you're not. You know, so it's really important that when you receive the refusal, you act promptly and to see what your options are, so you can plan ahead. Because you have, or even if your decision is to, I don't know, eventually leave, the earliest you understand your options, the better decisions you're gonna make later, right? So unfortunately, from time to time, some people come to our office where there is little time to appeal, or worse, when they have missed the deadline to appeal. Okay. Are you still lawful after a visa refusal? So short answer, yes, provided you held valid Bringy visa at the time of decision. Okay. Bringy visas during the appeal process. So an automatic extension. If you lodge a valid application for review with the Administrative Review Tribunal within the strict time limit, your Bringy visa is typically extended automatically. Okay, so you don't have to do anything. The system automatically extend your Bringy visa after you appeal, obviously. Work rights. In most cases, the conditions attached to your Bringy visa, such as full work rights, continue while your case is being reviewed by the tribunal. Okay, so so in most cases, like the conditions of your Bringy visas are carried over. Sorry, and maintain on your Bringy visa while the appeal is pending. The danger zone. So if you miss the tribunal deadline, your Bringy visa will expire. Right? Once you become unlawful, your options for staying in Australia diminish to almost zero. And you may face detention or a 3-year re-entry ban. Okay. So it is a serious situation to be in. Unfortunately, with the tribunal, specifically with the tribunal, if you miss that deadline, there is no other way to ask for an extension or for them to review. I mean, there is some ways, but they are applicable in very limited circumstances. Most people will not qualify for it, and it's so if you miss that one, then that's gonna start the clock on your Bringy visa, and if you already 35 days, 35 days on your Bringy visa already, you might run the risk of becoming unlawful, right? Which you don't want, because you might face detention or a 3-year re-entry ban. Okay. Um, Tribunal review versus court appeals, the key differences. So navigating the hierarchy of Australian reviews is complex. Since October 2024, the ART has replaced the old AAT as the primary body for merits review. Okay. So the key differences are the purpose, right? The tribunal is a merits review. They re-examines the facts of your case. So they're going to look the application from the beginning, and they are not restricted to follow what the department has decided, and they have the right to make their own view about the case, even if the refusal it's about a specific issue that the case officer might have seen or might have identified. The tribunal can also it's not obligated to reassess that particular point. They can assess the application as a whole and make a totally different decision, right? Courts are different. Courts are different. They are looking at whether there is error of law, and if the law has been followed correctly, right? So it's not about the merits whether you are eligible for a visa. It's more about has something unlawful been done or throughout the process, right? Unlawful in the sense that has the department or the tribunal follow all the rules when assessing this application, or has failed to failed to assess any evidence that was submitted, for instance, right? New evidence. Tribunal can usually consider the new documents and information. Usually that's what they do. They give you plenty of opportunity for you to submit information, new information. Courts, no, they'll look at what has been provided up to that point, right? Up to the tribunal. It only looks for legal errors. Outcome. Tribunal can overturn the refusal and grant the visa. It can also remit the application back to the department for reconsideration and approval. It's a strange situation because they remit back and said, look, you should approve this, but then the department needs to follow their own guidelines, which is just reassess the whole thing from start. So yeah, but at least you have a recommendation from approval from the tribunal. I had a hearing this week that I attend that we won for a client, and that's exactly what happened. The member sent the application back to the department for further processing with a consideration for approval. Okay. Courts can only set aside decision and send it back to be redone. Okay. Deadline. Tribunal apologies there usually is 28 days. They have, yeah, I know. Sorry, I know. I correct that in time. So usually 28 days. They have changed that recently. So in line with the other deadlines the department has given clients over the years. So there was always a confusion, like there was something really odd because all the deadlines that you see at 28 days, and the tribunal was the one that, there was only 21 days, and that could cause confusion. So they brought that in line with the other deadlines to appeal. So it's great because now it's like 20 days for everything, and courts usually 35. Okay. Now the ART it stands in the shoes of the department. They look at your application fresh, like I said. They look at the whole application from the beginning. If the department made a mistake regarding your work experience or relationship status, the ART has the power to correct, right? Courts, if the ART also refuses your visa, you may go to the federal circuit and the family court. However, the court does not care if you are of a good person or if decision feels unfair. It's about the jurisdictional error and whether that's been present in your case, right? So it's a much higher threshold that you need to overcome with the courts. Common mistakes that damage your case. I think that one it's a big one, which is self-representing in court, especially in court. Migration law is highly technical. Most DUI courts appeals are dismissed quickly because applicants argue the merits rather than the law. Okay. Ignoring the Section 48 bar, trying to lodge a different visa like a partner visa after student visa refusal without checking if you're legally allowed to do so. Some visas are you are waived from that Section 48. Okay, so you need to be sure which ones you need to be sure the visa you're applying for, it is one of them. Leaving it to the last minute. Law firms often need several days to review a file before they can safely lodge an appeal. Contacting a lawyer on the day, the 20 or 21 day deadline is a massive risk. So don't leave to the last minute. And again, the deadline is 28, not 21. So don't leave to the last day. You know, a lot of things can go wrong. System is not. It's not. The system is down, for instance, your internet or something. So it's always good to lodge way ahead. You know, rather than leaving to the last minute. Frequently asked questions. How long do I have to lodge an appeal? That depends on the type of appeal that you're lodging it. So if it's the tribunal, 28 days, courts usually 35. How much does an ART appeal cost? Is 3,580. Right. There was a big increase maybe a couple of years ago. Used to be, I think, about 1,780 and 50, I think, 1,750. But tribunal review their own costs and fees and decide to increase it. Can I still work while my appeal is being processed? That depends on your situation. That depends on the conditions of your bridging visa and whether they can be removed or not. How long does an ART take to make a decision? That varies. The tribunal, the ART, they publish the processing times on their website, so you can look at the official processing times there. But there is one thing that they're doing now, which is they have changed the guidelines and they are speeding up the process. So applications that more applications will be decided without the need for a hearing, because that's usually what slows down the processing times. So they are going to do more and more now. They're going to make more and more now decisions based on what we call on papers, right? On the documentation before them, which is good news, you know. sometimes like applications would taking too long, and where applications could be decided on with supporting documents without the need of a hearing, but that needs to be exercised with caution on that side, because not every single occupation hearing has a purpose, as well. So it has its pros and cons, but let's see what the tribunal is going to behave in the next year or so, and see how the processing times are going to look like. What is the Section 48 bar? As explained in the beginning, is when you have a visa refused in Australia and you hold a Bringy visa, you are Section 48 bar, meaning that you can't apply for visas here if you had a visa refused while holding a Bringy visa. What happens if the ART refuses my appeal? So if they refuse it, you have the option to seek ministerial intervention, but also this is a avenue that's being reviewed recently, and they're making even more strict to get that across the line, or you can lodge an appeal with the courts, right, as explained. Okay. Questions? Okay. Trying to read the questions here. Okay. Student visa got refused in Jan. Look, to whether you can stay in Australia, you can check your visa status using the department's website. You can get your passport information, put it there, and then they will come up what visa you currently hold, right? So if you were on a Bringy visa at the time that you submit the application and you haven't been contacted by the tribunal to attend a hearing or provide more documents, it's likely that you are lawful, that you can stay in Australia lawfully, right? Whether you can full time finish your studies, yeah, that depends on the your situation and the condition on your Bringy visa. The wording of some conditions in some Bringy visas are not very clear, although in particular with the student visa holders, then there's been some clarification on the website, actually, that they extract what it was in the legislation and put it on the website, so it's a bit more clear now. So I advise you to refer to that. But in generally speaking, once you finish your course, then and you're a primary visa holder of your student visa, you can work full time while the course is not in session, right? But that needs to be assessed on your situation, see whether you're studying or not, and etc. I'm still waiting for a appeal decision, but I was hoping to load another visa, maybe for H2. Okay. For John, I would suggest is we do offer consultations, but it is possible, with the Section 48 bar, when you have a visa refused, it only affects visas that are lodged in Australia. So you can lodge applications from outside Australia because the Section 48 does not operate outside Australia. But if you want any strategy or how we'll go about this situation, then we can look at your situation and have an initial consultation and see what the best thing moving forward. Yeah, the same with Lud. It is in specific questions, but no, you do need to go. You go to the ART, in because you need to exhaust all the avenues available to you first. And again, even if you could go to the court from the visa refusal, I would never advise you to do it, unless there is a jurisdictional error there, you know, because the courts are they, like explained here earlier, they assess applications differently, and you might ended up with, you know, a very big bill in the end if you don't know your chances are of winning that case in the courts, right? So even if you could, I don't know, theoretically go direct to the courts, which is, I don't think you could, but this is something that in reality, I would never advise anyone doing. Okay. All right. I think that's it. Okay, let's just go to next slide. Right. So if no problem, no worries, all good. It's if sorry, I was trying to read the chat there. I got a bit lost on what I was going to say. So expert guidance matters. So if your visa has been refused while in Australia, what you do next can determine whether you stay lawfully, challenge the decision, or are forced to leave, right? Many onshore visa refusals come with review rights and court appeal options, but these options are governed by strict deadlines, complex legal rules, etc. So unfortunately, most people only learn this after it's too late. So there is a QR code that you can see there. With that QR code, that can lead to a website, and we offer free consultations, free assessments, not free consultations, free assessments, and see what can be done from there, or if anything, or if you have any options. Okay. So I'm just gonna leave for a while, a little bit actually. Okay. Yeah. Oh, we also have new webinars coming up. There is one about labor agreements. Oh, thank you. Another one about financial well-being influences, testamentary trust, and tax planning decisions. These are with my colleagues in Queensland, because I clearly don't know anything about that. So it's if you want to register, then you can also scan the QR code there and register yourself, and you receive an email, and we go from there. So, like I said, thank you again. First of all, thank you for everyone attending it. I hope it was not too boring. If you need assistance, then you can either try that QR code, or you can go to a website, or if you like to, you know, you'll be more like old-fashioned like I am, then you can call us as well on that number. So that's it. I don't think I have anything further to say. Thank you, everyone, and enjoy your day.